My name is Shana O'Toole. I am the president and founder of the Due Process Institute and its sibling 501c3, Clause 40 Foundation. I want to welcome you and thank you so much for getting dressed and leaving your home offices to attend what is our 7th annual program, in which we ask two brilliant Constitution litigator scholars to help us explore key criminal cases from the Supreme Court's docket. My vision in creating Due Process Institute was a simple one: to create a bipartisan policy shop to preserve procedural due process rights in the criminal law. Barry Boss, your table is right over there. It's premised on the belief that regardless of political beliefs or partisanship, there are fundamental principles at work in our criminal legal system that we can all agree on. And I happen to think this program is a good example of that principle at work, as reflected by our speakers and our audience. Now more than ever, it is time for an organization like ours to exist, to bridge the very real divides that exist politically, to find our common ground, so that we can work together for common sense solutions in the public safety space. Due Process Institute considers itself first and foremost lawyers and lobbyists for the Constitution, and we employ advocates on both sides of the aisle. But we aren't just lobbyists. We also pursue our criminal justice reform objectives through the creation of cutting-edge research, scholarship, and through the strategic filing of amicus briefs. In just a few short years in which we've been in operation, we've helped draft, introduce, and pass numerous criminal justice reform laws. We have filed scores and scores of amicus briefs, some of which have actually even been on the winning side. And we have educated thousands of people on a variety of critical issues that need our attention. We are incredibly, incredibly grateful to the law firms that generously partnered with us today to sponsor today's event. I'd actually like to ask them to stand and stay standing if they can. Sorry, I'm already getting some eye rolls as I call them out. Shout out to Barry Boss, who has arrived on time, and his other colleagues from Cozen O'Connor. Stay up. Shout out to Blair Brown at Zuckerman Spader. Thank you to our friends at Jenner and Block. Shout out to Bill Pitterton, Matt Kaiser, and their colleagues from Kaiser. Come on, all of you stand up, come on. Thank you to the great people at Shirtler, Ornato, Meat, and Sears. Let's see it. Hi, Hank. Shout out to Andy Wise and a table full of great lawyers from Miller and Chevalier. Shout out to Jonathan Hacker and the team from Jeff's firm, O'Melveny. And certainly, last but not least, let's hear it for the team from Erin's firm, Clement Murphy. We could not put on this great event without them, so thank you for your partnership. I would also like to ask each of you individuals, if you get value from this program, or if you support the work we are doing in Congress or in the courts, please take the time now to support our work. Every dollar truly does count. We've made it easy for you. There are cards on your chairs with QR codes that will take you directly to where you can make either a tax-free donation to our C3, or where you can make a non-deductible contribution to Due Process Institute to support our lobbying efforts. And if you don't like QR codes, you can go straight to our websites and hit the donation pages there. And if that doesn't work for you, I am accepting cash on your way out the door. Thank you. And please know, money is not the only way you can support our work. We get amicus requests from all over the country every single day. Sadly, we have to turn some of them down because we just don't have enough partners in this work. So if you or your law firm, if you're solo, if you're a big practice, it doesn't matter. If you would like to join us in those efforts, please email me, come up and talk to me. I promise you I will get you involved in an amicus effort in an area of the law that intrigues you or that where you are an expert in, and we would deeply, deeply appreciate that support.
My name is Blair Brown. I'm a partner at Zuckerman Spader here in DC. I have attended this event and actually sponsored this event partially every year, or nearly every year it's been in existence, and every year I've learned an enormous amount. I've learned not only about specific cases recently decided and to be decided before the Supreme Court, but more generally about specific justices' approaches to these cases and trends in their thinking. And very importantly, I have learned that we should not think about decisions in criminal cases before the Supreme Court dividing along what is considered the usual ideological conservative liberal split. I'm primarily a trial lawyer, and I generally do not take the time to analyze Supreme Court opinions or think deeply or deep thoughts about where the court's going. That and much more is what our speakers do, and I'm very thankful to them for sharing their wisdom with us. I'm here to introduce one of the speakers, Erin Murphy. She is a partner in the law firm of Clement Murphy, and she is widely recognized as one of the nation's leading Supreme Court and appellate advocates. She's argued dozens of cases in appellate and trial courts throughout the country, including the Supreme Court and nearly all of the federal courts of appeal. Erin has been ranked as a top appellate specialist by Chambers and Partners, and the National Law Journal has named her one of the nation's outstanding women lawyers. She has litigated appeals involving many, many federal constitutional and statutory issues. Currently, she and her firm are representing Wilmer Hale in the litigation over the executive order directed to that firm and others that has received a lot of attention. And we're very thankful to her for that. And she is also representing the Maryland U.S. Federal District Court judges, all of whom have been sued by the Trump administration. There was a favorable district court decision, but as expected, the administration is appealing. She's been recognized as a litigation trailblazer for representing institutional clients, including successfully arguing before the Supreme Court on behalf of the U.S. House of Representatives and the Wisconsin State Legislature. She has an active pro bono practice through which she's represented many religious organizations and adherents, criminal defendants, asylum applicants, adoptive parents, and more. Erin graduated magna cum laude from Georgetown University Law Center. She clerked for Judge Diane Sykes of the U.S. Court of Appeals for the Seventh Circuit and was a Bristow Fellow at the Solicitor General's Office. She's an adjunct professor at her alma mater, Georgetown Law School, and a frequent speaker on topics related to Supreme Court and appellate practice. I have not seen Erin argue a case, but I've seen enough of her over the many times she has presented at this gathering that I would not want to argue against her. Okay, she is obviously brilliant. She's thoughtful. She's very clear. She's agile in her thinking. That is, can't speak to her, sports abilities, but she's very agile in her thinking. And I think she would be a formidable advocate for any client. So I give you Erin Murphy.
Good afternoon. My name is John Hacker. I'm the head of the Supreme Court and Appellate Practice at O'Melveny & Myers. We're very pleased to be co-sponsoring this lunch for you, and I very much look forward to the presentation. I am here and very pleased to introduce my friend and law partner, Jeff Fisher. After graduating from Duke University undergrad, Jeff attended the Michigan Law School, which coincidentally has trained at least a couple of the nation's finest appellate attorneys. After Michigan, Jeff clerked for Judge Stephen Reinhardt on the Ninth Circuit, and then for Justice John Paul Stevens on the U.S. Supreme Court. Jeff then worked for several years at the law firm of Davis, Wright, and Tremaine, where, among other things, he represented the plaintiffs in the Exxon Valdez case, and that's where I first met Jeff working on that case on the other side, and actually argued against him in a follow-on Valdez matter in the Ninth Circuit, and that was among Jeff's many appellate victories. Around that time, Jeff co-founded the Stanford Supreme Court Litigation Clinic, where he's been co-director for almost 20 years. And we at O'Melveny were extremely pleased to welcome him to the firm's Supreme Court and Appellate Practice Group in 2018. In his various capacities over the years, Jeff has argued 50 cases in the U.S. Supreme Court, which I think is among, that number is among private lawyers, is the most among private lawyers who are not alums of the Solicitor General's office, and is more than most of them too, including actual former Solicitors General. Jeff is known as a dean of the criminal defense appellate bar. Many of his Supreme Court arguments have involved criminal law and procedure, sentencing, and related issues. But he's also briefed or argued cases on marriage equality, reproductive freedom, free speech, and religious rights, international law and jurisdiction, and federal civil procedure. Many of Jeff's cases appear in law school casebooks, or they did back when the court wrote opinions that law students could actually read in the casebooks. He has too many professional accolades to list comprehensively, but they include being named one of the 100 most influential lawyers in America by the National Law Journal. The accolade I find most interesting, and discovered just this morning, though, dates all the way back to law school. Confirming his law nerd status very early on, Jeff published not one, but 2 student notes in the Michigan Law Review. And while it is impressive that one note won the law school's award for the best student note, I actually find it even more impressive that the other note won an award for the second best student note, which is an award I think they must have invented specially for Jeff. And as if all of that weren't impressive and annoying enough, Jeff is also an avid and excellent skier, golfer, tennis player, and basketball player, which I know personally because I've competed against him in all of those sports. And I've been about as successful in those endeavors as I was in that Valdez argument almost 20 years ago. Jeff, we very much look forward to hearing from you and from Erin. Enjoy.
Well, thank you. It's always especially embarrassing to have an insider introduce you, so thanks, John. And it's great to be here with Erin and Shana and all the folks that we get to see year after year. This is something that I circle on my own calendar and really look forward to see old friends, meet some new people, and just share an afternoon together, so thanks for coming out. We're going to kind of do the same thing we've done in recent years, which is Erin and I will start with a few thoughts about the court in general, some general themes and trend lines, before pivoting into the heart of the matter, which is the criminal law docket at the court and criminal justice issues. And then maybe at the end, draw the lens back out one more time and talk about, as we look ahead to this term, there are so many other kinds of big cases and issues potentially headed the court's way, and share a couple thoughts about that. And last but not least, about 1:45, try to leave room for questions. So I'll just start by saying a couple things that are probably going to sound fairly obvious, and I'm curious to get, part of the fun is always getting Erin's views on these things too. But I probably don't have to tell you all that the very nature of the court's work, let's leave aside for a moment the bottom line substantive decisions, but just the very nature of the court's work is changing so dramatically right before our eyes. The court has steadily declined the number over the last several years of ordinary merits cases it hears every term, hovering around 60 a term now. But meanwhile, the court has dramatically ratcheted up the amount of emergency docket or shadow docket rulings the court has issued. And just to put these numbers in perspective, to give you a sense of kind of what the court is facing. In the Obama and George W. Bush presidencies combined, so you're talking 16 years, remember, because you had two-term presidents, I believe the government went to the Supreme Court asking for emergency relief once every 2 years. When you got to the first Trump administration, the government was going up to the Supreme Court asking for interim relief once every month. Now the Trump administration, the next Trump administration, and of course I'm just hitting highlights, this has happened on the other side of the aisle as well, but just shows you the trend line. The current Trump administration is on average asking the Supreme Court for emergency relief once a week. So in the space of all of our lifetimes, you've gone from once every 2 years to once a week. And these are not small matters, right? These are the front pages of our papers or our feeds. These are huge public policy issues, issues of national security, international law, et cetera. And so through a variety of forces, some maybe the court's own doing and maybe some beyond the court's power, it is now spending so much of its work on these emergency, I'll put it in quotes, sometimes maybe a true emergency, maybe we could debate that, but these emergency orders, and hearing cases in their just nascent form, complaints that have just barely been filed, records that have scarcely been developed, even legal arguments that have buried, that are just really just kind of coming into bloom. And then the amazing thing, as again, most of you may know, is, at least in terms of the numbers and the outcomes, the court has been siding with the government again and again and again recently. I think we're almost near 20 in a row where the court is staying or otherwise adjusting the interim posture of litigation in the government's favor. And so I think one thing that we're all wondering is this a Supreme Court that just is kind of favorable to Donald Trump's agenda or the things he wants to do, if not him as an individual, and they want to support that, and that's what they're going out of their way to do? Or is it something that we saw, the reverse effect during the Biden years, where certain district judges may be issuing orders that sort of get out too far on their skis, to use the skiing metaphor from earlier. That happened sometimes during the Biden presidency. The Supreme Court stayed district court orders. And so one thing that I'm wondering, I don't know, Erin, I'll pivot over to you on this for your thoughts on the shadow docket, but your own clients aside in the District of Maryland, I wonder about district judges. I've never heard in my lifetime so much of district judges looking over their own shoulders at the Supreme Court, and the Supreme Court reacting so much to district judges as opposed to Court of Appeals judges. And that whole dynamic where the Supreme Court and trial judges are directly interacting has a kind of a new thing for the legal system, I think.
Yeah, and I think there's just I think some of it's the way you pose the question, like a little bit of both. Because I think part of the message that I take the court to be sending is, look, if litigants are going to go into district court and treat everything like it's an emergency and we need relief tomorrow and you can't really take the time to think about our case before you enjoin what the administration is doing, then it's a little hard for everyone to say, well, the Supreme Court should really sit back and let this all develop. If everybody else, and you get the same dynamic with the courts of appeals and doing all of this stuff really quickly. And I think we saw a little bit of that from Justice Kavanaugh responding to some of this in one of his opinions when he sort of said, like, if all the important decisions are going to be made really quickly, really early on, I'm not sure why we should sit on the sidelines. And so some of that is, kind of a feedback loop in both directions. People are like, why does the administration go up all the time and they're asking for this relief? Well, maybe you don't have to walk in and ask for the most assertive, aggressive relief as quickly as possible in every case and kind of tee it up that way. And I understand why people do. And there's a lot of scenarios where I get it. I get why they, from both sides, you'd view this as like, this is a really big deal. And it matters a lot to make the initial determination about what the state of the law is going to be while we litigate this. Yeah. But I think it's a little unfair then to say to the court, like, everybody else can move quickly, and they all don't really need a lot of time and facts and law, but like you do. What are you doing stepping in? Of course, that is the norm that the court had for a long time, but I don't think we had quite as much. I don't think the district court litigation looked quite the same, and you didn't kind of go in necessarily and try to enjoin every single thing that happened quite so quickly. Obviously we got the issue of nationwide injunctions up at the court last year in large part because that's a phenomenon that had really grown in the past 10, 15 years. So I think some of it is that. Now that said, not every case where the court is intervening obviously fits that pattern, and there are some where I think some of it is less reactive to the emergency nature and more reactive to the way they think the lower court, that they maybe just think the lower courts are getting out over their skis legally in terms of how they're dealing with issues. And I also think, as much as it seems, they're obviously going to the court a lot, but they're not always going. And the administration is making decisions, calculated decisions about what they think they can press and what they think they can't. And you're certainly not getting the signals from the court of stop, we don't want this, and it's hard to fault an administration for seeking the relief if you've got a court that seems to agree that there are situations where we need to be intervening. So it is a huge part of the court's docket, and it's a really interesting phenomenon, but I think there's many components to it, and I think you kind of have to put some of it on the way district court litigation is shaping up, some of it on administrations being much more willing to go to the court, some of it on the court being much more receptive to it, and they just sort of all of those things align in a perfect storm. I thought one of the really interesting things last year that I'm not sure we'll see repeat this year, but was that you actually had some really different dynamics. If you looked at the court's merits docket versus the court's emergency docket, if you look at the merits docket, you see that most of first of all, what people thought of the biggest cases, some of them were not 6-3, and the cases that were 6-3 were almost evenly split about who was the three, whether it was kind of the three justices furthest left, furthest right, or some combination of the two, but you didn't have, only about half the cases were 6-3 in the sense of the conservative 6 justices. And you look at those numbers of just generally agreement and disagreement on the court. The highest agreement was among the justices kind of at the furthest ends of the spectrum, even more so than the justices who are more in the middle of the court. And so you saw kind of a tale of a lot of polarizing at the two ends of the spectrum, but a lot more unpredictability about the justices in, not even just the three in the middle. You've got some unpredictability with Justice Gorsuch in some different areas, and Justice Kagan not always aligning and all of that. But then you look at the emergency docket and you see much more of the kind of conservative liberal divide, 6-3, or at least 2 stating their views. It's unclear to me if that has anything to do with it being the merits docket versus the emergency docket, or whether it's just a product of the cases, and that those cases, since they're going to be the merits cases this year, whether we'll see anything similar, or if that was just sort of an oddity of last year. Or maybe we continue to see that more in the cases that aren't the most classic Trump administration cases, but may still be some of the big cases and divisive cases. So that's just something that it was a trend you saw last year that I'll be interested to see kind of how it plays out this year. That's
a great point. I actually wonder whether it's not an accident, in the sense that one way you think about what the Supreme Court really has been essentially good at as an institution over the years is a deep dive into a case of the way that they're ordinarily litigated, with lots of briefing, amicus briefs, oral argument, time to percolate. And you could say one thing that's going on in that process is every justice, every person, every lawyer in this room has preconceptions and has initial instincts about a legal issue when it's presented to us. But the point of the process and the point of the deep dive appellate process in the Supreme Court, and you and I have seen this happen in our own cases, is to test those assumptions and push hard against them, and to give time for air and oxygen to all the arguments. And things then pivot, coalesce, compromises happen, narrow pathways are found. And that seems to happen to me less and less, just by the way the emergency doctrine is structured. And so what worries me about it, I think, and this is picking up on something that just happened a week or two ago, where Justice Gorsuch kind of reprimanded a district judge for not following the precedent of the shadow docket, of a prior shadow docket decision about jurisdiction over defunding disputes. And it's one thing to do that interim order, but then to ascribe it the same level of precedential significance that is typically due to these much more long, drawn-out, process-oriented decisions worries me a little bit, I guess. No, and I think it creates a particularly interesting dynamic on the heels of, if we just go back a couple terms to something like the Moyle case that involved, how to think about the abortion regulations under EMTALA, and the court had granted emergency relief, sort of, and then the case got there and it changed so much, and they ended up just kicking the case and saying, we need to know more. And I'm not sure there won't be some of these scenarios where, and I think if you read some of their opinions that are on the emergency docket, you see some saying, we're not denying that we may need to know more, but if we got to
say our instinct now, our instinct is this is what the status quo should be while we figure out more. And so, I think it would be a really interesting and probably a good thing for people to see process-wise if you saw a few cases where it turned out somebody's like, look, like any judge, I've got to make a decision quickly early on, and I may not have all the information, and maybe things develop in a way where the parties refine their arguments, the parties refine the facts, and you come to a different conclusion. And that's why, I'm of a mixed mind about two things that I think the court has tried in response to a lot of public criticism about this docket. You don't tell us what you're doing, and you make decisions without, and I think they've responded by saying more in their opinions and by taking some of the cases up and bringing them out of the shadows into the docket. And I think both of those things have, people, they've both been with mixed success. Because then you have everybody saying, well, you say all this stuff on the shadow docket and you shouldn't be getting out ahead of yourself and maybe you should say less. And then they've had some experiences where they took the cases up and realized, oh, maybe there's a reason we let the arguments kind of get developed below. So it's something I'm watching just to see, I think the court is still working through. Did we have it right back in the day where we kind of said nothing and just granted or denied relief and called it a day? Will we see them move back in that direction? And did we have it right when back in the day, kind of viewed it as, look, we may have to make an interim decision, but that doesn't necessarily mean the case is ready for us to decide on the merits. And maybe we should be kind of, absolutely, there's some cases that are pretty pure legal issues that are easy to pull up right now and deal with quickly. But maybe some other ones, even if we have to get involved early, we should give that really time to develop below. And I think, probably the answer is a little different depending on the case.
Yeah. Well, maybe we'll pivot a little bit into the criminal docket.
Yeah.
By way of doing that, it is noteworthy, of course, that I don't know of any criminal cases that have appeared on the shadow docket or in the emergency posture. Sometimes capital cases do, I guess, would be the most classic exception, but leaving that aside. It's funny, when I was preparing to talk today, it occurred to me that having done other kinds of Supreme Court panels where what we just talked about takes up the whole day, it's actually kind of refreshing and wonderful to talk about the criminal docket for some of the reasons we've already had gestured at today, which is among the areas on the court's docket, it is less ideologically driven, I think. And it is actually, and the temperature is lower. Shana was talking about the Constitution. Well, a lot of these cases are just statutory cases, too. And statutory cases in an area where Congress may well actually respond to the Supreme Court's decision. There could be some dialogue. And I think I'll just say as a Supreme Court lawyer, I kind of like the criminal docket more than ever. It's not that I don't like the other stuff, but I like being in there in a world where the justices can surprise you more than ever. Justice Gorsuch is particularly independent in these areas. And then depending on what the issue is, maybe there's another textualist vote with Justice Barrett for the defense, or maybe there's a fairness argument that's going to appeal to the Chief Justice or Justice Kavanaugh. And on down the line, you have different people, and Justice Jackson favoring the prosecution more than some outside lookers might predict. So all the way down, the court is, I think, particularly interesting and thoughtful. And so it's kind of like a lovely area of the law right now amidst our broader times to be talking about. So by way of just hitting a few of the high notes from last term and this term, I will start with a case that I handled called Coussis against the United States last term. This is about the federal wire fraud statute, and as many of you might know, the statute, which the wire and mail fraud statutes prohibit a scheme or artifice to defraud somebody to obtain money or property. And prosecutors have, for decades, treated this statute as a bit of a Swiss Army knife for public and private corruption and dishonest behavior that seems to warrant criminal sanction, but maybe you can't quite squeeze it into any particular box. And the Supreme Court has continually pushed back against that, kind of year after year. So I went up representing a defendant last term to end that streak. I lost a case on behalf of a criminal defendant involving the wire fraud statute, but let me tell you about it and what it might still leave open. So starting point for these cases is the Supreme Court has said over and over that these Maryland wire fraud statutes protect only property rights, not anything more general than that. And there have been a series of cases, as I said, where the court has said that something like the right to intangible honest services is not a property right, or some other intangible abstract right. And a few terms ago, in a case called Simonelli, the court, and the latest of those lines of cases, invalidated a theory from the Second Circuit known as the right to control theory, which had to do with a bidding process where somebody withheld crucial information from the governmental entity giving the contract, received the contract and did all the work at a fair price and did a good job, and was nevertheless prosecuted for wire fraud for concealing that conflict of interest information during the bidding process. And the Second Circuit said that was a valid conviction because there's a right and economically valuable information during negotiations. And the Supreme Court said, what are you talking about? No way, 9-0, we reverse. But during that litigation, the Solicitor General's office came up with a new theory that had scarcely been used in the past, but aimed at kind of getting ahead and responding to the court's concerns about the wire fraud statute, where they said, look, in these cases, what you really ought to do is think about just the money under the contract, the money in any economic transaction as the property interest at stake. And so the government's new theory, called the fraudulent inducement theory, was if you lie or make dishonest representations during negotiations or the like to obtain money or property from somebody that they might not have otherwise have given you to induce the transaction, that constitutes wire fraud under the simple theory that that you're getting property, you're getting the money from the person, and it meets the other elements of the statute. And so the objection that was raised by the defense bar to this theory is, no, wait a minute. The wire fraud statute and the mail fraud statute as a historical matter still requires some harm. So if you sort of use puffery or lies to get somebody to go into a transaction, it shouldn't be a criminal offense at least. It might be some civil offense, but it shouldn't be a criminal offense unless the victim is harmed. So just to give you a couple of examples so you understand the problem, because it all kinds of different ways. There's an old case from Arkansas from the 1800s where a hotel operator told somebody, this is the hotel where your brother stayed and he loves staying in this hotel. The person makes a reservation, stays in the hotel. Turns out the brother had never stayed there. But it was a good room at a fair price and whatever, and the Arkansas Supreme Court said, well, that's not fraud. It's not criminal fraud because you weren't injured. There's a more recent Ninth Circuit case involving somebody who's selling printer cartridges and says, I think the price is maybe going to go up next year, so you might want to buy a whole bunch now. The person buys it at market price, is convicted. The Ninth Circuit overturns that and says, no, there's no harm there. And then a hypothetical. There were a whole bunch of babysitter hypotheticals at the Supreme Court, and I gave the example of what about a babysitter who says, I want the job because I'm going to use the money to pay for college, and actually what she's doing is she's going to go out with her friends and have a party over the weekend, and lies about how she's going to use the money. That might cause the person to hire that babysitter instead of somebody else, but is it fraud? So you get an idea of the problem, and that's what the court tackled in Cassis. The particular issue in Cassis was another government contracting case where my clients had promised to use a portion of the funds to use minority disadvantaged-owned businesses to provide some of the materials for the job, and then didn't use it to the level that they'd promised to do that. But nevertheless performed the job under the price of the contract and did a good job. So what happened in this case is the Supreme Court actually ruled 9-0 that the government's new theory, at least insofar as it was argued in Cassis, is actually valid. The Supreme Court said when money changes hands, that's a property interest the wire fraud statutes cover, and there's no requirement that a victim is harmed beyond, if you want to call it, the harm of being fraudulently induced to enter the contract or to enter into the transaction. And so then the question becomes, well, gosh, what about those hypotheticals I just gave you, or any number of others you could think of? Is everything now, every white lie or puffery to get somebody to enter into any economic transaction now mail or wire fraud? Well, that's where the court stops its analysis and says, no, the materiality element of the statute will still take care of that. So is the lie serious enough to be material under the contract negotiation becomes the big issue. The Supreme Court didn't answer that question in Cassis and leaves it for another day. So I think what the court did probably to a fair degree is just shift all this dispute and litigation from one element of the statute to another. And under the Gaudin case decided decades ago, materiality is generally a jury question. And so I think what the takeaway in these cases is a lot more of these indictments are going to get through the motion to dismiss stage and would ultimately defeat an insufficient evidence claim, but the jury is going to be a lot more pivotal in these prosecutions, for better or worse, as we see them.
Yeah, no, that seems right. I mean, and it is really interesting that this ended up kind of unanimous in the other direction on the heels of all these other cases, as I mean, it seems. It seems to be at a point where some of them are very focused on kind of the textual component of it, whereas this one, I think I just got much more of a flavor of just sort of a like practical, like, look, that feels to us like sort of you're defrauding somebody. And it seemed like that was more the instinct of, okay, we've said all these things and they're really important about when you have like things that feel like really, really attenuated theories. But this seems different. And to me, the best thing I can do to kind of pinpoint it is I think a lot of what is driving the court when it comes in particular to the fraud statutes is thinking about it through the lens of fair notice and the defendant, and like whether you would appreciate that what you were doing is something that somebody would think of as fraud. And I think on some of these theories that have come along over the years, they're like, that just doesn't seem like the kind of thing where you would understand that. And I think they have a different reaction in this context of, look, if you are essentially, kind of lying to somebody to get something, you kind of understand that what you're doing, there's something, if you assume that to be true, setting aside kind of materiality like that maybe there's just an element of it that I think they have the more of the reaction of, we don't feel the same fair notice concern, the same, we're going well beyond the bounds of the types of things, that people are typically worried. But it seems like, some of this started, I think, absolutely back in Simonelli with the kind of, you could tell there that some of them were already thinking, look, we don't like the way you're coming at this, but that doesn't mean that you might not be able to get at the same egregious fact patterns through another lens, and I think they've given it here. But at the end of the day, as you say, like materiality is a real thing, and it's going to matter, and I think some of the hypotheticals clearly fall on one side of the line versus the other, so, but you're absolutely right. That's going to end up meaning a lot more cases go forward.
Yeah, for all the trial lawyers in this room.
Yeah. Bad for your clients, maybe not for you. So I'm going to talk about Thompson versus United States, which is kind of like the same debate, but through the lens of falsity and false versus misleading. So this is a case that involved the federal prohibition on knowingly making a false statement to influence the FDIC on a loan. And the basic question was whether that reaches statements that are technically true but may be misleading. And so the fact pattern here was that the defendant had taken out 3 loans totaling $219,000. One was for $110,000, and the other 2 were for smaller amounts. The bank he took them out from failed, and so the FDIC comes calling him to collect on the loans. And as they're saying how much money they think he owes, it's like the 219 plus interest, and he's basically kind of says, I don't remember that number. I borrowed $110,000. And he says that a few times, and that's the basis for the conviction that he was making that representation. And so the case, but what an interesting component of this is it's not a case where the jury was instructed that it could find, it could fine for the government if the statement was either false or misleading. They were instructed they had to find a false statement, and they found that there was a false statement, but he basically said that the evidence wasn't sufficient to sustain the conviction as a false statement, and the Seventh Circuit had precedent that said that misleading is fine, and so they affirmed the conviction on the ground that it didn't matter if it was only misleading. So the case went to the court on that question of whether the statute covers misleading statements that aren't themselves false, and the court unanimously sided with the defendant here and said it does not. It's a notable opinion because it's really just like a very bread and butter statutory interpretation opinion written by the Chief Justice. It just kind of walks through false doesn't mean misleading necessarily. They're different words. There are lots of different statutes in the code, some and many that actually use both false and misleading. So we're going to take from the fact that Congress didn't use that here, and also this provision's like codified with a lot of provisions that use only false and not misleading. And it really is just kind of like mostly focused on that statutory text and context. And you don't get like much of a flavor in the opinion of any of the kind of like, and we're really worried people wouldn't like appreciate this, or we're really worried about kind of in some of these opinions when there's sort of a sense of like this is driven by concerns about prosecutorial overreach. It's really just a pretty bread and butter statutory interpretation decision. But what was interesting to me then, you also, along with that, you have two concurrences by Justice Alito and by Justice Jackson. And they both are essentially, Justice Alito oddly just kind of like says, I understand the opinion to say this, and then like says the opinion. Like there's absolutely nothing that anybody would be confused about. But then the last part of it is, and by the way, I want to make clear that the Seventh Circuit didn't resolve the question of whether these statements are actually false. And you have to look at context, which is one of the things the majority says, just because, basically the point that both the majority and Justice Alito were making was a misleading statement may be false in context, and sort of if you think about it here, like if you were asked, did you take out a loan for X amount, and you respond and said, I took out a loan for 110, like, that's gonna be false. Whereas, and they made clear, you've got to look at all of that surrounding context and not just take literal falsity by looking at the words themselves without understanding what question prompted them or whatever it may be. So he sort of makes that clear. And then Justice Jackson does him one better and writes a concurrence to explicitly say, this is clearly false and he should just lose. Which is notable, as you've said, she hasn't quite been where everybody thought she might be for criminal defendants on stuff. I did think she specifically, though, kind of begins her concurrence by saying the district court didn't do anything wrong. And so I almost processed it more through the lens of, we kind of took this case, and I don't want anyone to be under like a misimpression that the jury got the wrong instructions or anything actually kind of wrong happened at trial here. They were told to find a false statement, and they found a false statement, and really this could only be sustained if looking in context, there's no way you could understand these particular statements to be false, and she would have just gone ahead and resolved that question essentially. She basically just said, and he should win on remand, and essentially the Seventh Circuit should just enter judgment. Which also, one of the just broader trends you tend to see in all these cases is like, the court is never happy anymore just dealing with the legal question. Like somebody's got to weigh in on what we think the actual right answer bottom line is here. And in almost any of these cases, even when you see the unanimous, like usually somebody will kind of write to say that, even if you have a case where the court purports to leave that question on remand.
That's so true. And then you wonder when it's only one justice or maybe two justices writing separately, does that mean that the other 6 or 7 or 8 disagreed, didn't actually believe that, or that they just truly didn't want to reach it? And I think lower courts kind of struggle with that sometimes. And it's interesting, these first 2 cases we've discussed were unanimous bottom line. Even that, though, is I think noteworthy of a court that is talked about as being so divided. And I think both oral arguments, it's fair to say, were both really kind of difficult to read. They struggled with both sides of hypotheticals on both sides and all the rest, but nevertheless they coalesced in conference, or at least in the opinion writing.
It's one of the nice things about this area, like if you process the court through looking at cases like these, you're like, oh, they look very functional, and they all like are thinking hard and debating with each other, and not like grandstanding with questions that are more for the press than themselves. It's like you see some of the best of the court in cases like these.
And also maybe one noteworthy thing, and I'll do a next case, is when you mentioned Justice Jackson writing separately, that was one of the other things probably worth noting from last term. If you didn't know, the justice who wrote the most separate opinions of anyone on the court was the most junior justice on the court, which is, I don't know if that's ever been the case, but she's working very hard to, I think, make a voice for herself. That's something that I think to continue watching is how that plays both inside the building, and I think oftentimes she's probably speaking to people outside the building in those opinions as well.
Yeah, no, and particularly interesting because we've been seeing her do that for a while, and then we're just like sort of starting to see Justice Barrett be like, maybe I'm gonna enter into this.
Yes.
I'm gonna get a little responsive and put out some of my own stuff. So they're just gonna have an interesting back and forth to watch for years to come.
Well, I'm going to talk about a case where they actually didn't come out unanimous. Actually, I'm going to do 3 cases in one involving the First Step Act of 2018. So this was a bipartisan criminal justice reform legislation that DPI played a very instrumental role in. And between last term and this term, 3 cases on the docket involve interpretive issues arising out of that law. And actually, it's, I'll pause before I get into the guts of the case and just say, one of the common features of Supreme Court panels in recent years have been, where have all the cases gone? We're down down into the 60s in terms of the merits docket. And one of the theories among many has been, well, maybe there just aren't as many cases to decide because there aren't as many statutes and being passed by Congress. And maybe this is like a point in the column for that theory, which is Congress actually passed a significant law, and lo and behold, a handful of years later, we've got cases in the Supreme Court about it. So the case last term was called Hewitt, and there were basically 2 big features of the Fair Sentencing Reform Act. It reformed the so-called stacking problem that arose out of gun prosecutions where multiple convictions required multiple 25-year mandatory minimum sentences to be stacked on top of each other. And then there's an adjustment of mandatory minimums in drug crimes. And so starting with the stacking side of the equation, the issue in Hewitt was who gets the benefit of this new law. Obviously, everybody prosecuted going forward gets the benefit of it. But what Congress said, to make it a little more interesting, was not exactly that, is that all defendants where a, quote, sentence has not been imposed should get the benefit of the law. So obviously, if you haven't been through trial yet, you get the benefit of the law. Everybody agreed that if a defendant had been prosecuted and his sentence had been vacated for some reason before the law was passed, at that new sentencing, he'd get the benefit of the law. But what about somebody who was prosecuted and sentenced before the law was passed, then his sentence is vacated for some other reason, and now he's up for a new sentence? Is that somebody who gets the benefit of the law because his sentence has not been imposed? In the sense that a vacated sentence, we often say, is a nullity as if it never occurred as a matter of legal fiction. So when the district judge is doing that new sentence, it's as though it's happening for the first time. Or do you take a more literalist approach to that language and say, well, he was sentenced before as a literal matter a few years ago, even though we treat it under the law as a nullity? And so that statutory interpretation issue divided the court 5-4, with the majority holding that the legal fiction was the better understanding of the law, that you should treat a defendant in that situation as somebody who's never been sentenced at all. That opinion was written by Justice Jackson and joined by the other 2 Democratic appointees, plus Justice Gorsuch and the Chief Justice. What's maybe most interesting about that opinion is it's a multi-part opinion that starts out as a textual opinion. And the 2 conservative justices who created the majority joined that part of the opinion. Then the rest of the opinion talks about congressional intent and legislative history and the like, and they do not join that part of the opinion. And what I think is kind of interesting about that is, okay, I'm not so sure that still explains the outcome, because I had another case involving the same issue, and even when you dig deep, 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 it's really hard. And Justice Kavanaugh, at oral argument, said this is a really close issue with no clear textual answer. And so to say that text completely decides this case, I think, is hard. What I think is the best way to decide this case, which is what Justice Jackson said, is, look, what Congress basically said is we don't want to have a retroactive law that lets everybody go back into court and get brand new sentencings. But on the other hand, if you've never been sentenced or you're already getting sentenced again for some other reason, you get the benefit of the law. So we're not creating any new work for district judges. We're just applying this, this law, which we think more fairly reflects the purposes of criminal justice in this day and age in sentencing to anybody who's already being sentenced anyhow. And that, to me, seemed like the best way to resolve the case, but it's interesting that 2 of the 5 members in the majority forswore that purposive congressional intent approach as part of their reasoning. Maybe you want to say a word about that before I took off the other cases?
I will say, like,
I've kind of baited maybe you.
There's an element of that that's got to be partly like, it's like the line in the sand. I mean, like when Justice Scalia used to drop the thing, have the footnote that I join everything in the case, but footnote 3 or whatever. Like, I think some of it's more. I mean, obviously, she's pushing very hard to make that part of the analysis again, and some of that may just be part of the broader dialogue between among the justices.
So there are 2 cases this term, also under the Fair Sentencing Act, involving a different provision of the law that allows defendants to be resentenced under the compassionate release concept let me put it this way, a district judge can reduce a prison term for extraordinary and compelling reasons. And the key words are extraordinary and compelling. So the issue in the first case, which is actually 2 in 1, Rutherford and Carter, is whether a district court may consider the sentencing disparities created by this lack of retroactivity in the law that I was just describing. So if you had somebody who was sentenced under the previous law and got a 150-year sentence for 6 gun offenses stacked on top of each other, is that an extraordinary and compelling reason to grant an early release? And the debating statutory interpretation arguments are from the government side. The government says, well, that would just defeat Congress's choice in deciding whether to make the law retroactive. A district judge can nevertheless reduce a sentence to somebody who the law doesn't apply to under the existence of the First Step Act and its new sentencing principles, that would defeat Congress's retroactivity decision. On the other hand, the defendant says, well, no, just if you want to be a textualist here, so again, the textualist purposive arguments, if you want to be a textualist, it just says extraordinary and compelling. There's no limitation on what can be extraordinary and compelling, and if a district judge reasonably believes that it's out of whack to have such a gigantic sentencing disparity, just as a quirk of timing, you might say, then the defendant ought to have the ability, to at least persuade a district judge to use their discretion to reduce the sentence. The other interesting thing about this case is it raises an issue also about the Sentencing Commission's power. So the United States Sentencing Commission has issued a policy statement siding with the defense view that it is okay to reduce a sentence on this ground. And one of the arguments one of the 2 defendants makes is that the Supreme Court should defer, or at least pay serious respect to the view of the United States Sentencing Commission on that question. Now, I just said, some of you might have just heard the word defer in the same word as Supreme Court and been asking yourself, well, does that happen anymore? Are we allowed to do that anymore? And you're thinking of the Loper-Bright case where the court says, at least a matter of ordinary administrative law, the Supreme Court will no longer defer to reasonable interpretations of statutes by administrative agencies. But in the Loper-Bright case, the court did carve out the situation where Congress has expressly delegated to an agency the power to issue interpretive rules or policy statements. And what the defense says is that is actually the situation here. So this tests one of the, you might think of the exceptions of Loper-Bright, or one of the parts of the Chevron doctrine that still lives today, which is when Congress expressly delegates to an agency, what does the Supreme Court do there? And so this could be, I think, maybe the first opportunity of the court to look at how that principle plays out, at least in the context of the U.S. Sentencing Commission. And then finally, the Fernandez case also involves the same statute, the extraordinary and compelling reasons provision of the ability to reduce sentences. And that raises yet another question, whether or not a district judge can consider something that would be cause for a Section 2255 motion, in other words, a post-conviction relief motion that the defense could otherwise bring as an extraordinary and compelling reason to reduce under the compassionate release statutes. In other words, we have another situation where there's an alternative pathway available potentially for making an argument. The government says we shouldn't also be able to bring it over here. And the defense makes the same move in this case as the defense makes as a statutory matter in the Rutherford and Carter case, and says, look, there's no statutory limit, there's no textual limitation on extraordinary and compelling. And in fact, in one other place in the law, the court said that rehabilitation cannot constitute extraordinary and compelling. So Congress actually spoke to what might be off the table, and it didn't take this particular subcategory of arguments off the table, and that ought to be good enough. So, so these will just be really interesting cases where the court kind of rolls up its sleeves, again, like Erin was saying about Thompson last year, and does statutory interpretation, and then we get arguments about textualism versus purposivism, I think.
I'm going to jump right into the substantive docket so we can make sure we're leaving some room for questions. So the court, they don't take a whole lot of like actual substantive constitutional criminal law questions these days, but they did a little last year, or doing a little bit this year. So last year the court had a case, Barnes versus Felix, that dealt with the use of excessive force under the Fourth Amendment, and basically it was a question about essentially what circumstances you can take into account under the test that governs, which is that you look at whether the use of force was objectively reasonable under the totality of the circumstances. As the case came to the court, essentially the question was, can you only consider the circumstances at like the precise moment that force was used, or can you look a little bit more broadly? And it arose out of a fact pattern that was basically a traffic stop. Law enforcement had pulled over the individual, Mr. Barnes, for outstanding toll payments, and during the course of the stop, Barnes told the officer he didn't have his license on him, and the officer asked him to get out of the car. He opened the door but wouldn't get out and instead started driving, and the officer jumped onto the door sill of the car, and as he kept driving, he couldn't really see him and was telling him to stop, and he didn't, and so he fired twice into the car. Ultimately, Mr. Barnes died. And so the question as it came up out of the Fifth Circuit was essentially, could you only consider like the moment he was already on the sill of the car and the individual was driving away, or could you take into account kind of what happened before, what the circumstances were that sort of led to the stop and him driving away and him being on the sill and all of that? The court unanimously said totality of the circumstances means totality of the circumstances, so you're not confined to looking at the precise moment of the stop, and didn't say a whole lot more than that. And so I think this case ends up not doing a heck of a lot because it was really just teed up in a pretty unusual posture. There's an actual kind of substantive issue that's divided the courts below, which is really more a question of can you hold that a use of force that otherwise wouldn't be excessive, that was an objectively reasonable response to what happened in the moment, is nonetheless a violation of the Fourth Amendment if the officer did something unlawful or unreasonable that prompted the need to use force. That's the real question that courts have struggled with. And this case didn't really tee that up because the Fifth Circuit had essentially written, it was a panel who obviously didn't like Fifth Circuit precedent, and so they described it in this cartoonish way where they said, we can't look at anything but the 2 minutes that he's standing on the sill and our hands are tied, and the court said, of course, that's not right. But they refused to decide the question, even though the officer, Felix, said, look, this is the real issue, and you should really reject this notion that, if the officer commits some other independent wrong or constitutional violation, that somehow that could convert what otherwise is a reasonable use of force into an unreasonable one. And the court just basically said, we don't really want to say anything about that. And then that's an issue they refused to say anything about a few years back in another case that had raised it. And there was a concurrence here authored by Justice Kavanaugh, joined by Thomas Alito and Barrett, but they didn't say anything really about this either. He just wrote something separately to say, look, traffic stops are an extremely difficult situation and you really should be sure you're understanding all the circumstances, including, just how quickly they can go wrong for officers when you're assessing the way that they use force. So it's definitely a very, kind of written to be sort of law enforcement friendly, but they still kind of just conspicuously all stay away from what I think is the real question, And I don't know. I mean, I did a cert petition on that question a few years ago, which they did not grant. So they just seem to not actually want to resolve it, even though there is some actual division in the lower courts about that issue.
Yeah, that is a hard issue.
Yeah.
That is a hard issue. And I know I hear it in your voice, I'm always the most bitter when they deny cert in a case that
I love it. It's a great case. Yeah.
But I think it is a hard question. Let me keep us moving. I want to mention, though, one other Fourth Amendment case that's in front of the court this term, so you're aware of it. It's called Case versus Montana, a case called Case versus Montana. Another case about policing. This case involves the so-called emergency aid exception to the Fourth Amendment, or the community caretaking function of the police. The question is whether the police need probable cause or alternatively a lower level of just reasonable suspicion to enter somebody's home, a private home, to deliver emergency aid. And this case arises out of a phone call from a woman who said that she'd just broken up with her boyfriend, and that he was suggesting he might commit suicide. And so the police actually went into the home and found him and arrested him for possessing a firearm. He wasn't committing suicide, but the facts suggested that if the police had just dug a little deeper, they might have realized that it was kind of an idle suggestion and maybe wouldn't have met the probable cause standard. So that's the legal question in front of the court. You can imagine it arising in lots of other situations. An elderly person who usually takes an afternoon walk isn't seen. An ordinary 5 o'clock walk around the park. Somebody's walking past and they hear glass breaking in a home, or maybe smell smoke coming out of a window. Is it just the chicken is burning in the oven, or is there something more serious happening? So the issue is pretty significant, and there are basically competing arguments in the case. On the defense side, about the sanctity of the home, and in many amicus briefs from across the political spectrum, hammering the special sanctity of the home and saying nothing less than probable cause should ever suffice to enter somebody's home. On the other hand, the government says, the state of Montana, and says, when the police are performing non-investigatory objectives, in other words, they're not doing criminal investigation, you often let something less than probable cause serve as good enough to render aid, for example, which is something you want the police to do. And so those are kind of the general competing arguments. Two quick things I'll be watching in the case. One is just what I think of as the long shadow of Wren. So many of these cases really, to me, matter because of the Supreme Court's holding decades ago that you don't look at subjective intentions of police officers. So the worry from the defense side in these cases is once you allow less than probable cause as a reason to conduct some form of a search or entry, you open the door to what are really investigatory actions under the guise of community caretaking and the like, and Wren just looms so large in modern policing and criminal law, and I think that'll be prominent in the background here. And then the other question, which the court may or may not address, is when we say probable cause to trigger the emergency aid exception. One is like, what exactly is the emergency aid exception? Is there somebody in life-threatening condition? Is it serious bodily harm? Maybe significant property damage? Like, what exactly is the community caretaking function, at least as it pertains to the home? That's not directly presented in the case, but again, that's another way to make the police officer's authority much broader or narrower, depending on how you write the rest of that sentence. And so that'll be something else I think I'll be watching.
And then I will talk briefly about Villarreal versus Texas before we take some questions for you guys. So this is a Sixth Amendment right to counsel case that I think this question's really interesting. I'm also curious, like, if it really arises or if everybody figured out ways around this for the most part. But the court took it, and it's one that I could very much see odd lineups when they ultimately resolve it. So. The question is whether whether when a criminal defendant testifies on their own behalf during their trial, if the court takes a recess during that testimony, is there a right to consult about the testimony with counsel during that recess? It's commonplace, obviously, for courts to tell witnesses that they can't talk to counsel during breaks, but the court has confronted a few times the idea that that is a potential constraint on the right to counsel under the Sixth Amendment in the criminal context, because you may be consulting, a criminal defendant may need to be consulting with their lawyer about other aspects of the trial during the course of the trial. And so the court has confronted this question a couple times, but quite some time ago. Back in 1976, there was a case called Getters. I don't even, do you know how it's pronounced? I just sort of assumed that. It's not a case I was super familiar with, but, and what the court said back there, that case was where basically there had been an overnight recess, and the court instructed that the criminal defendant couldn't speak with his counsel at all during the recess. And the court said, no, that's too much. It's a 17-hour recess. You may need to talk with counsel about the way the trial is going. That's what you often do at the end of a day of trial. And so we think that having a complete bar on being able to talk to counsel for a period that long is a Sixth Amendment violation. This is 1976. That's a unanimous decision back then. Who knows how that issue would come out now. But the defendant there wasn't even really arguing, I should be able to consult with my lawyer about my testimony. It was, I should be able to at least consult with my lawyer. And then the court came back to this issue in 1989 in a case called Perry versus Leak that dealt with a much narrower context where the court just took a 15-minute recess between the defendant's direct and cross. And the Supreme Court said, no, like 15-minute recess, that's really short. You wouldn't normally be consulting with your lawyer about anything except your testimony during that context. So we're going to say that's not a problem, and they can tell you can't talk to your counsel at all during a recess that short. And so it's sort of left these bookends of like a really long recess and a really short one, and the question open of, okay, well, during the long one, can there be constraints on what you can talk with your lawyer about? Can the court say, and this is what happened in this case, the court said you can talk to your lawyer during this overnight recess, but basically, in not the clearest of ways, but essentially said, but please don't talk about your testimony. And the courts, and so here that was affirmed by the Texas courts, which might make you think like, oh, the court took this up, even though that came out that way. There's a pretty established split on this, so I think that's probably why they took the case. I mean, it seems like the majority of courts have actually said you can't have these constraints and you have to allow essentially unfettered access to counsel, which is, of course, the criminal defendant's argument here. I think it's an interesting and tricky one. If you look at the earlier two cases, both of them seem pretty premised on the idea that if all you wanted to do was talk about your testimony, that would not be okay. Generally, you're not allowed to get coaching mid-testimony from your lawyer. And in the Perry case, the court very explicitly said that when a defendant becomes a witness, he has no constitutional right to consult with his lawyer while he's testifying. He has an absolute right to such consultation before he begins to testify, but neither he nor his lawyer has a right to have the testimony interrupted to get the benefit of counsel's advice. And what the court then said in Perry was, that said, we recognize that during a 17-hour recess there may be some discussion about your testimony, but we're like going to err on the side of saying we're not going to say you can't talk at all to your lawyer during a long recess, even if we know in all likelihood you'll end up talking about your testimony. And like if you kind of frame it that way, where you think of it as, well, it's just sort of like an overbreath problem, I can see the argument. On the flip side, if you actually frame it as like a criminal defendant has a right to consult with their lawyer about their testimony in the midst of the testimony, that seems like a much harder sell, and especially if some of the justices here start really getting into this from more of the historical tradition way, that some of them are inclined to look at substantive constitutional questions. I mean, the scope of the right to counsel as presently understood is probably a lot broader in a lot of ways than historically it was understood, and I think they might have a tough time with the idea that there's a right to that. But I thought some of the most powerful arguments that are made by the criminal defendant here are along the lines of, this is just not it's a hard line to draw. What if the lawyer wants to consult with their client about, look, I heard what you said on the stand today, and in light of that, we should really take this plea deal that's on the table. Like, how do you decide what side of the line you put that on? And I think there are some line drawing problems in trying to figure out how to say, what exactly counts as you can't talk about this because it's straight up coaching versus, you're sort of talking about, trial strategy more generally in ways that might implicate the testimony, and which is probably something those of you who actually do trial work, which I don't, have a sense of if it really is a workable line. But I could see the court getting, some of them really thinking a lot about like, this seems like a line that makes sense constitutionally, but is it a line that is workable in practice?
Yeah. Well, before we take questions, I would just say something. I think we'd be remiss if we didn't very quickly mention the fact there are a handful of other very, very big cases and issues on the court's docket for this term, or about to be on the court's docket potentially for this term. And I'll just tick off two very, very quickly. I think executive power is going to be a shock to you all, no doubt. But executive power is potentially going to be a very big theme on the court's docket this term. The court has already taken up the case involving the legality of the tariffs that the administration has been issuing, principally under the International Emergency Economic Powers Act, otherwise known as IEPA, which gives the president the power during a national emergency to regulate imports to deal with an unusual and extraordinary threat to national security. And so in a nutshell, I think the best way to understand this case is it's in some ways the converse of cases that occurred during the Biden administration. When the Biden administration tried to use broad readings of certain statutes to do climate policy and student loan forgiveness, the Supreme Court invoked something called the Major Questions Doctrine and said, yes, we could read those statutes broadly to allow this regulation, but that's such a big deal that we think it's better to assume Congress didn't actually delegate that kind of authority without expressly saying so. So one way to understand the tariffs case is, in a sense, the shoe's on the other foot, and how does that come out in the tariff situation? So there's a political way to look at this question, of course, but I think there's another layer, which is, does the national security context and does the presidential authority context in this particular setting make a difference? And I think that'll be interesting to watch. Obviously interesting and incredibly important to see how the justices deal with these arguments in that context, where the question is whether regulate even includes using tariffs, and whether the situation constitutes, right now, the trade imbalance constitutes a extraordinary threat, an unusual and extraordinary threat to our country, as the administration says it does. And then the other case that isn't officially on the court's docket yet, but I assume it will be, comes out of the Fifth Circuit, involving the Alien Enemies Act, and the question of whether the president has power to summarily remove individuals on the theory that they are part of a gang that is tied into the government of Venezuela, and therefore is undergoing an invasion or predatory incursion of our country. The Fifth Circuit actually said no, the Alien Enemies Act does not reach this current setting. Judge Oldham wrote a 130-page dissent for the Fifth Circuit, taking not so much a different view of what it means to have a predatory incursion or an invasion, but rather just saying, if the president calls it that, we need to defer to the president. So again, I understand this AEA case as it comes up is really an executive power case, not so much like what do the words of the statute mean in this case. So that'll be another biggie.
Yeah, and then probably a removal, all the firings, that type of removal, president's removal power case. The other two big buckets are really active term coming up for election and campaign finance law. The court appears to be thinking about whether to hold Section 2 of the Voting Rights Act unconstitutional, and the court has taken a case about overturning precedent on coordinated expenditures for political parties in the campaign finance context. And then, of course, there's a couple of pretty big transgender area cases, the Childs case that involves the First Amendment, whether they're First Amendment rights in the context of kind of talk therapy, counseling, in the context of gender identity, transitioning, detransitioning, how the First Amendment applies in the context of those kind of regulations of that type of therapy, and the Title VII cases that involve the constitutionality and viability under Title VII of the many state laws that have said that, that biological boys cannot participate in girls' sports at public schools. So lots of really big stuff already on the docket for this term, with plenty more to come, I'm sure.
So while I let everybody here think about the questions they want to ask, I'm going to throw out a question to Jeff. Erin will understand why I'm not asking her. Erin and her partner, Paul Clement, have filed a cert petition seeking review of a matter that essentially asks the court to abolish Pinkerton conspiracy liability. Due Process Institute, of course, filed an amicus brief in support of that idea, written by the brilliant John Klein, calling Pinkerton liability the kudzu of the federal criminal law, because we like to be subtle like that. Do you think they're going to take the case up? And if they do, what would they do with it?
Well, it's a great question and a super important issue, and yes, the bane of the existence of many a criminal defense lawyer over the years, and criminal defendant even more over the years. I think the thing that's interesting about whether the court will take that up is right where Erin and I just left off. I mean, what a rich diet the court already has in front of it, and some of those cases, at least one involving the president's removal power, are going to put a very big precedent in the crosshairs, Humphrey's executor. And I always think of the court as having only so many chits every term to outright overrule cases, in the public, kind of in the public eye and in the eye of the bar. And so that to me becomes the challenge in cases like this. Like, I do think occasionally the court will reach out and overturn a case that it just is persuaded is wrong and harmful. But I think it's a little harder now than it used to be to get those cases in the door, where the court is so active and so busy in so many other agenda items and things that are just being forced upon it. So fingers crossed, but I think that's the hurdle to get over.
I'll also follow up to you. Like, the one thing I could see cutting against that is if I think it's a case that's going to cross over in terms of who's willing to overrule it, then you might be like, we like this idea since we can point to all the justices sometimes think stuff should be overruled. Do you think it's the kind of case, though, where it's like the justices who are so anti-overruling stuff would be like, man, we even got to let this one go? Because that's an interesting dynamic to me.
It could be. I mean, I was involved in a case like that a few years ago called Ramos against Louisiana, where you got a cross-coalition to overrule a case. But then no sooner did that happen than it was thrown back in the faces of some of the justices that voted.
No, it's
so
tough,
how it ends up cutting, I
but
don't
it's
know.
hard for me to see the left, the three most liberal justices being like, yeah, Pinkerton, you know. So,
right.
But
Don't bum us out, Jeff. Don't bum us out. All right, questions for our guests.
All right, thank you. So my name is Jeff Simmons, Jeffrey, of course. My question is to you, sir. So actually, we were recently exploring the case of Obergefell and Hudges. It's a very important decision in our country, and I've seen where the court was very adamant that the 14th Amendment, it requires that we have due process. And so I believe you were sitting as co-counsel for the plaintiff, and I'm in agreement with the court on this, that due process is important. It is so entrenched in our Constitution. But how do you feel at this time when the court is being asked whether a pastor who denied to marry a same-sex couple, how do you think the court could actually determine that, though this 2015 case actually set a precedent currently?
Right, so I think you may be asking a couple of questions about the Obergefell decision and the right of same-sex couples to marry. I think the first question is that decision safe in the court, especially after Dobbs, where the Supreme Court has tightened the screws on due process analysis? My takeaway is yes, at least as the court is currently constituted. I don't think there are more than maybe 3 votes to revisit Obergefell. I think that Justice Kavanaugh told us explicitly he thinks that Obergefell is safe. And so maybe it's a different discussion to say how do you reason that out and distinguish one from the other, but just as a matter of bottom line votes, my sense is the decision is safe, at least as the court is currently constituted. The other question, though, was will it be extended or how will it be applied in other settings? And there, I think it's a very different different answer that we've seen already with various free exercise claims and the like, where the court seems to understand Obergefell as a deal, which is that same-sex couples can have the right to marry, and states and the federal government have to recognize those marriages, but others in society that are private institutions, whether they be religious or other, have other sincerely held beliefs, don't necessarily have to, if you will, participate in those marriages. And so I think that's the way that, again, Justice Kavanaugh, who's a pivotal vote, has said out loud he understands that decision. The Chief Justice was, of course, a dissenter in Obergefell, and I think agrees with that. So I don't expect the decision to be applied aggressively outside of its own four corners. I don't know if you have any different.
No, the only other thing, I mean, I agree with you that I don't think they're interested in revisiting the decision itself. Some of this is a little bit of what's lurking, that the deal, I think, is a little bit lurking in the background of the Childs case.
Yeah.
Because, one of the powerful arguments there is that the way that Colorado law that's at issue there about therapy seems to work is that it's okay to provide talk therapy if you're sort of encouraging somebody to transition, but not if you're encouraging somebody to detransition. And I think if the court has that take on it, I think they're really not going to like the idea of using even what you might otherwise think of as regulation in a medical profession in a way that seems like it's sort of taking sides in some of these debates. I think you just see that same thing going on, that same kind of idea going on in some cases that are not directly the same issues, but the same kind of concept of, wait a second, we didn't mean to be saying we're completely on one side or the other of the social debate about a lot of these difficult issues.
Other questions? We have a whole table of students.
Shannon, there's one over by the window. Yeah.
Perfect. Coming. Monica from NACDL.
Yes, hi. So I guess I'm interested in, I see that the court has taken up fewer and fewer state cases over, let's say, like the last 10, 15 years. And why do you think that is, and what impact do you think that's going to have on essentially criminal defendants in different states?
Yeah. It's a great question, and it's certainly a true empirical fact that the court's hearing. So again, it's hearing fewer cases overall, so that could be part of it. But I think even as a percentage, it might be hearing fewer out of the states. I'll give you one theory, which is that it takes 4 votes to grant cert in any case, or to summarily reverse, it takes 5. And one of the pieces of the court's docket over the years had been criminal defendants bringing cases from state courts and saying something went woefully off the rails here. And you had 1 or 2 of those a term over the years where the court took them more to reverse than they took them to solve a circuit split like the Villarreal case. And what I've noticed, especially since Justice Barrett joined the court, is that, and the court became a 6-3 divide in certain ways, is that you see fewer of those cases landing on the docket, and I wonder if it's because there just aren't 4 votes to grant cert in those cases. In fact, I've been involved and seen a couple of others where you've had 2 and 3 justice dissents involving things like Brady violations or other constitutional claims coming from state courts. And so that's one species of state court case that has, if not disappeared, is sort of fallen away significantly on the court's docket. And I think that's too bad. I think the states ought to be watched over a little more closely sometimes. But I don't know if you've had any other theories, Erin, yourself, but that's one thing.
I mean, the other piece of it too is they just don't seem to take as much like substantive criminal law, which seems like a constitutional criminal law, which is what's going to come the most out of state courts. And it's not like they're taking like a disproportionate volume of that out of the federal courts. They just seem to be taking less of it. And so, maybe that just sort of itself ends up having an impact that lowers how frequently you're going to end up with cases coming out of
And
state
for all
courts.
we just talked about how they get together and go across ideological lines in criminal cases, That's definitely true in the statutory cases. It's true in some of the constitutional cases, but not others. So if you think about like Miranda rights, the Fourth Amendment exclusionary rule, the Eighth Amendment's cruel and unusual punishment clause, some of those are more traditionally ideologically divided. And so if a criminal defendant is bringing up a case saying my Miranda rights were violated, like there is not much of a chance there's going to be votes to grant that case on the court, because the liberals aren't going to want the court to touch it, and the conservatives are going to say fine with me if you didn't get your Miranda warnings.
And you have some where like I think they're just aren't even clearly 5 for like
the underlying rule.
like they just have different methodological ways they like it's part of what makes it fun and interesting, because I don't think they are as clearly kind of this is one ideology and this is the other, and you kind of come at it through that lens. In this context, you have some issues where I don't think they all see Fourth Amendment doctrine the same way, and I don't think I see a lot of aspects of Sixth Amendment, certainly not Confrontation Clause doctrine, and the court doesn't love taking cases where they think they might be fractured, and I think some of the substantive constitutional criminal law, they rightfully worry that might be where they end up.
All right, well, thank you both very much for your time and your talent. Let's give them both a round of applause.